Me versus Staff Team Hotels Corporation and Frank Winston Crum Insurance. Is counsel ready to proceed? Again, counsel, while you're approaching the podium, we reserve 15 minutes per side for this argument as well. Would you like to reserve some time for rebuttal?
Yes, Your Honor. 5 minutes, please.
So noted, Madam Clerk. You may continue.
May it please the court? My name is Nicolette Sambus, and I'm here with Brad Smith, who is also representing the claimant with regards to the pending appeal. So Mr. Bonham was an individual who was injured on the job on May 22nd, 2019. He had an injury that was unknown to him, although at the time of the accident, he felt some pain. Specifically, he described it as an electricity feeling from his head down to his toe. The employer carrier denied the case. They argued notice. That was the first issue that was bifurcated by the judge of compensation claims. It was heard, it was addressed. The judge denied the case, denied the employer carrier's notice defense. At that point in time, the case proceeded on to a subsequent final hearing. So I think what's important to be noted by this court at the onset is the fact that the parties presented evidence based on what happened to the claimant initially after the industrial accident. So on May 22nd, he felt this pain. He doesn't necessarily know what it's related to, goes to the emergency room several days later. At the emergency room, he describes symptoms like stretching on the right side of his body. The hospital, which, as we all know, is required to triage a patient, right? They're there to make sure that no one's dying, that you're going to be seen, that there's no heart attack, there's no stroke issues, there's nothing like that. So they work up the case for a heat exhaustion. That's where he was diagnosed with. The EMA that was appointed in this case, Dr. Scott, even acknowledged that the symptoms of stretching on the right side of the body is not something that would necessarily be associated with heat exhaustion. And I think that that's important because in the answer brief raised by the employer carrier, they note that for 2 months after the alleged industrial accident on May 22nd, he's only having symptoms of heat exhaustion. Well, that's not true. That's not what's in the record. The record's important to note that even the EMA, the allegedly presumed correct opinions of the EMA, he acknowledges that the stretching symptoms on the right side of the body, the weakness that was subsequently complained about at the subsequent hospitalization on the right side of the body again, and then even the numbness sensations that are experienced by the claimant on the third hospital visit, these are all symptoms that are not consistent with a heat stroke, heat exhaustion, right, dehydration type complaint.
And your client knew that each of the times that your client went back to the hospital, that there was something going on, not heat exhaustion, and presumably traceable back to that day in May, right?
My client didn't know. I mean, he's an individual from Haiti.
Well, why did he go to the hospital?
He went to the hospital because he's having pain, and he's being told by the hospital that it's heat exhaustion. He doesn't know as a non-medical provider that it's not heat exhaustion. He just knows that he goes to the hospital, they say heat exhaustion, he goes home, he's still having pain. So what's going on? He goes back to the hospital.
Well, but it isn't the problem. Dr. Scott says it wasn't related to the May 22nd incident, the herniation that he may have had. So although there may be some evidence to the contrary, how was it error for the JCC to say that didn't amount to clear and convincing evidence to the contrary of the EMA's opinion?
So that brings me to the premise of the whole appeal, right? The presumption of correctness that is to be applied to the EMA. The claimant, and I'm not here to argue that the presumption should not apply to Dr. Scott's opinion at all. Dr. Scott was appointed as a neurosurgeon to address spinal injuries, to address whether the claimant had a spinal injury, a herniation, like Your Honor just indicated. Dr. Smith, the claimant's IME, did indicate that there was a herniation in the cervical spine. However, he also indicated that there was a sprain strain, that there was a cervical spine pain injury. That was both opinions, right? So the claimant concedes that the EMA opined that there was not a herniation and that opinion needs to be afforded the presumption of correctness. I will agree that that is That is a question that was posed by the JCC, whether there was a spinal injury/condition with regards to the May 22nd, 2019 industrial accident. The EMA says, no, there is no herniation. That should be afforded the presumption of correctness, and I'm not here to argue otherwise. The case law is clear that the EMA should be afforded with the presumption of correctness as it applies to disputes and questions that are raised by the judge of compensation claims. Here, the judge of compensation claims asked about spinal injury/condition because there was an allegation that there was a notation that Dr. Smith was noting that the claimant may be a surgical candidate because of that cervical herniation. Dr. Scott, as the EMA, differentiated between the condition of a spinal condition, which is like a herniation, a nerve-related complaint, versus a muscular complaint. It's not the claimant that made that distinction, and that's what was indicated in the answer brief, that the claimant's making up this distinction, that there's no distinction between the two. It wasn't the claimant that came up with it. It was Dr. Scott in his deposition testimony who opined that there is a clear difference between a muscular injury, like a sprain strain, versus a herniation, surgical issue, a neurosurgical element, which is something that Dr. Scott is able to opine on. Dr. Scott is a neurosurgeon. He is an expert medical advisor. I'm not disputing his qualifications, but I am arguing that the JCC improperly applied the presumption of correctness, and that is clear by this court, has noted on several occasions that questions that are not posed to the EMA are not to be afforded that presumption of correctness. And in this case, the judge improperly applied that presumption. If the presumption was not applied, then you have a physician here, Dr. Scott, who opines that the claimant does not have a sprain strain related to the May 22nd accident because of a temporal relationship.
Well, counsel, what do you contend is the injury that your client suffered?
A cervical spine sprain strain is,
Okay, and what are the manifestations of that? Like, how does that manifest itself?
well, I'm not the doctor, but in the record, the manifestation of the claimant's symptoms were, well, he was lifting those mattresses on May 22nd, 2019, feels that pain, but he doesn't know what it is. Then he goes to the hospital. He describes the stretching sensation from the right side of his body, starting at the head cervical area, radiating down. That's consistent when he goes back to the hospital, references weakness on the right side. Consistent again when he goes back to the hospital because the symptoms are waxing and waning. Dr. Scott confirmed that these are symptoms of a sprain strain, waxing and waning of symptoms, numbness radiating down the body. These are all similar symptoms of a sprain strain, which is reiterated by Dr. Smith's own testimony. So you have these consistent findings, and then you have a physician who simply states, well, it can't be related because 2 months passed. But it's not 2 months past where there was no symptoms. It is 2 months past where the claimant repeatedly goes back to the doctor and is seeking help for a condition that was caused by a work-related accident on May 22nd, 2019.
Right. Counsel, that's not why I was asking. I'm asking
sorry.
because I'm trying to understand how it is that your client didn't know on that day or the day after, or at least a couple days after when he goes to the ER, that he didn't know that there's something manifesting. He doesn't know what it is necessarily or why, but he knows that something happened when he's lifting those mattresses, that suddenly he's experiencing some pain that very well may be debilitating. You're saying, and the JCC just fast forwards and goes and looks at the July date when there's a diagnosis. It sounds like the JCC is taking the position that it's the diagnosis that is the date and not the first manifestation of the injury. Do you disagree?
If I understand your question correctly, you're saying that the judge of compensation claims is assuming July is the date of accident? Is that what you're asking?
Well, that's when the injury was either occurred or first manifested, and that's when the 30 days would run.
Well, and that's the judge is the trier of fact, right? He's supposed to determine the questions of fact that are raised, and that goes to the notice issue. The judge of compensation claims noted that the claimant, as a reasonable person, he weighed the credibility of the claimant and assessed that it was a medical diagnosis that was required of the claimant. He knew something was going on.
What is that basis, though? That's what I'm asking. So that sounds like a legal conclusion that doesn't necessarily match up with the statute. It sounds like the JCC actually did just that and said that it has to be a diagnosis. notwithstanding the fact that the client or your client is saying, I experienced pain on May 22nd, on May 23rd, and this is ongoing. And the JCC just blew past all of that and said, hey, well, there's a diagnosis in July, so that's when it first occurred.
I respectfully disagree, Your Honor. The claimant had pain. That does not mean that he knew he had an injury. That does not mean that he associated the pain that he was experiencing with a cervical spine sprain strain. And that's clear in the evidence that he didn't know. And you go to the hospital as any layperson and you're being told that you have heat exhaustion, or it's because your AC is not on. Are you, as an individual, going to contradict the expert testimony? And that's exactly what happened here. He didn't know he had an injury. He had pain. There's a difference. I see that my time is up for my rebuttal, but I would just like to note that the key points on this appeal is A, that the presumption was inapplied, and then B, with regards to an overall determination, a remand is necessary for the judge of compensation claims to apply the proper standards. The judge of compensation claims made notations with regards to the diagnoses that are made in the hospital records, but then at the same time, he noted, and as the EC pointed out in their answer brief, those hospital records were supposed to be only admitted for the claimant's state of mind. So the judge erred in relying on diagnoses such as the heat exhaustion made on the hospital erroneously or secondarily to what was actually going on with the claimant. He relied on those diagnoses when he specifically noted that the hospital records were not admissible from that standpoint, and they were only supposed to be admitted for the state of mind. So I think that that's important, that the judge was not following the proper procedures and properly assigning the burden of proof and the necessary presumptions in this case. So I'll reserve the remainder of my time for rebuttal, please, unless there's more questions.
Thank you, counsel.
May it please the court.
You may continue.
My name is Bill Rogner, and along with trial counsel Rogers Turner, I represent Staff Team Hotels and Frank Winston Crum Insurance. Judge Tannenbaum, you sort of hit the head or hit the nail on the head for our cross appeal.
I like the other one.
You know what I meant.
I do.
So what the claimant did was he testified 3 different times in this case. The first was in his deposition. The second was there was a hearing on his motion for a $2,000 advance, and that transcript's in the record as well. And the third time was at trial. And what the claimant said all 3 times was, I was lifting mattresses, I remember it clearly. It was the 4th trip lifting mattresses when I felt these pains. And he's asked by trial counsel, and did you associate the symptoms you were feeling with the action of lifting those mattresses? And he said yes all 3 times, okay? So the question is, does the claimant have to simply know that I did something at work and this something at work did something to me? Is that the triggering event for notice? Or, on the other hand, does the claimant have to go get a diagnosis? You have a herniated disc at C3-4 and you have a lumbar strain or something like that, right? Before the claimant has the burden to report the injury, and I say no, and I cite the case, the Ludke case, which is in the briefs. And in Ludke, it was the same thing. Claimant did something at work, associated symptoms or pain with the thing that happened at work. And the court said, you got to report that. We don't have a requirement that a claimant has a medical diagnosis before they have to report the injury if they understand that something occurred at work that injured them, and that's this case, okay? Now, I was curious to hear that they have no problem with Dr. Scott being the EMA, and they have no problem with the presumption of the correctness of his opinions, because the first point on their appeal was an allegation that the judge made a mistake in the first place by appointing Dr. Scott as the EMA doctor because he was too qualified to serve as the EMA doctor. The 2 doctors involved in the case were both IME doctors. Dr. Friedman said, I don't believe there's an injury that was related to work. They hired Dr. Richard Smith. Dr. Richard Smith said, not only that I think he was injured on the job, but I think he's got 3 herniated discs, and I think he needs to be evaluated for surgery. And then they asked the judge to appoint an EMA based on the conflict, okay? So what is the allegation at the time the judge is faced with the decision of who do I pick for this EMA? Well, the allegation was he has a surgical condition. He's got 3 herniated discs and he may need surgery. So the judge goes, I need to pick a spine specialist, somebody who's capable of looking at this case, and he does, right? So he picks Dr. Scott. Now, Dr. Scott testifies about this alleged inability to consider soft tissue injuries, because what they say is, in their brief, they say it was below his pay grade. And that's certainly not what Dr. Scott said. What Dr. Scott said at page 487 of the record is that I am a spine specialist. I treat both surgical and non-surgical conditions, okay? Now the question that matters in this case, the judge asked several by number. He did a very detailed list of questions he wanted the judge or wanted the doctor to address. Question 1 was, what spine injuries, not surgical spine injuries, what spine injuries are related to the work accident? And he answered the question directly in this manner, quote, there was no injury to the cervical or lumbar spine or spinal cord or nerve roots. He answered it all. He didn't parse and say, I'm not going to address the strain. And they're sort of pretending in hindsight that it was just a strain claim from the beginning when actually they were asserting that he might have a surgical case.
Counsel, let me ask you a question, statutory. So the JCC needs to appoint an EMA in the relevant medical specialty, unless there's not one available, and then pick someone else. Who makes the determination whether, well, first of all, how close does a JCC have to get to the what is close enough to be relevant medical specialty? And then second, how is a record made of whether there's one available such that then the JCC can appoint anyone to be an EMA?
Right, there wasn't anything in a hearing, for example, where somebody said, I tried every orthopedic surgeon in town, or I tried every whatever doctor in town, and we couldn't get anybody else to do it. Right? Sometimes we have that in these cases. But I reject your assumption that the EMA doctor must be of the same medical specialty as the doctors that disagree, and I'll explain why I say that. First of all, the one-time change statute, which is where we did have a holding that said it has to be the same specialty, says the doctor in the same specialty, okay? The second reason is that EMAs are routinely appointed when doctors of different specialties disagree. And the reason is that the EMA statute doesn't say if 2 doctors in the same specialty disagree. What it says is if 2 healthcare providers disagree, the judge shall appoint an expert medical advisor. Sometimes that's a walk-in clinic and an orthopedist. Sometimes that's a physical medicine specialist and a neurologist. And so if there was a requirement that it must be in the same specialty as the doctor that disagrees, and I've got 2 doctors in different specialties, then I would be looking at appointing multiple EMAs, because you can't get one that has both specialties.
Well, right. So isn't it possible to read the statute as it's relevant to the JCC, and isn't the JCC that determines what the relevancy is?
Absolutely, and he did a more detailed order than what I usually see when he appointed the EMA doctor. He explained why he wanted to get a particular specialist, and Dr. Scott is an extremely well-respected spine doctor. And their challenge to him now, keep in mind, think about this, okay? The order appointing Dr. Scott as the EMA, it says Dr. Scott, neurosurgeon, in case they didn't know he was a neurosurgeon, right? The order says that. That's September 11th. No complaint. No motion for rehearing. Nothing. Then the report comes out October 12th, adverse to their position, which is why they don't want Dr. Scott to be the EMA. But do they file a motion then? Do they raise an objection then? No, they do not. Next opportunity to do it would be December 10th when he was deposed. Dr. Scott was deposed twice. First was December 10th. Do they object to his qualifications? No. They don't have any objection to his qualifications. They don't make any noise about him being a neurosurgeon. Second deposition, January 21. Do they say anything then? No, they don't. But you know what they do is 6 days later, they file a motion to strike his testimony. It's not in the record. They did not include it in the appellate record. They're the appellant. They have the obligation to bring you a record on which you can make a determination. But they did not object to him being a neurosurgeon in that motion. The only subject of that motion was a Daubert objection, which is point two of their appeal. And there was a hearing held on February the 1st over the Daubert objection. There was an order entered addressing the Daubert objection, finding that the judge rejected the objection, and that's not in the appellate record. The only thing that's in the appellate record is our response. And if you want to know that there was an order entered, you can go to page 6 of the record. It's the docket, and it's right there. As you know, docket number 87 is the order denying their Daubert motion. So as far as their second issue, which is the Daubert motion, they're arguing this, Judge, and you just said 12 days ago they can't do it. They're saying their evidence is superior and should have been accepted, and therefore the judge should have rejected the EMA opinion. Our evidence is better than your evidence. And what you characterize that as, typically in your cases, is either A, frivolous, or B, baseless. And you just did that in the Ranger Construction versus Brand case, came out 12 days ago. So the question on appeal, and you heard counsel stipulate that the doctor gets the presumption of correctness, is whether there is CSE in the record to support what the judge did do, not whether there is compelling evidence that would have supported the judge doing something else. So I don't think there's any merit to that argument.
Counselor, can I ask you a question about your cross appeal?
Sure.
So the appellant mentions, I think once at the beginning of their initial brief, something about that the claimant actually did provide some notice through the WhatsApp and some other notes, and those are exhibits 7 and 9. Why is that enough, not enough, or does it even count?
Well, I know it wasn't really the subject of the judge's factual findings in the order, so I don't know what relevance they would have. I mean, there's nothing in those communications where he reports a work accident. I mean, the concern we have, or the belief we have, is that there was never a work accident. I mean, factually, here's what happened. They filed a petition alleging a May 24 date of accident. They litigated it for 7 months before dropping it because he never worked on May 24. Undeterred, claimant picks a new date, May 22nd, and we start all over again. Now, he goes to the ER these 4 visits in May and June, and you will not find the word work in any of those reports other than to say he wasn't working. You will not find mattresses in those 4 ER records. You will not find lifting. None of it's there. What you will find is in the assessment, negative for neck and back pain. Negative for neck and back pain, right? And then we get to July 17, Judge Tannenbaum, the one you bring up, right? July 17, he's back in the ER. For the first time, he has neck and back pain, okay? We have an onset date. He says when it started. Did it start May 24? No. Did it start May 22? No. When did it start? July 16, 20 hours earlier. Onset of pain, 20 hours earlier. He's there on the 17th. That puts us on the 16th. Well, on July 16th, was he at work? No. No. He'd been gone for weeks, hadn't been working for weeks. And when he does have this onset of pain on July 17th, does it say mattresses? Does it say lifting? No, nothing. And Judge, back to the cross appeal, we take issue with the judge's factual findings. We assert that they're not supported by competent substantial evidence, and I'll give you a clear reason why. 2, actually. 1, the order finds that he was told at the ER on July the 9th that his neck pain was related to work, okay? The claimant wasn't there on July the 9th. There's no dispute as to that, right? So we file a motion for rehearing because this appears to be something that would be characterized as a readily correctable technical mistake. And you've told us in your cases, I got to file a motion for rehearing. We file a motion for a rehearing and we say, hey, Judge, he wasn't there on July the 9th. You can't make that finding. Motion denied, okay? Second thing, the order says, and I quote, The medical records indicate that he was told at the ER that he had a cervical strain that was work-related, close quote. Not true. There's nothing in those medical records that indicate he was told that. Claimant says that, right? But if the finding is the medical records indicate that, and there's nothing in the medical records about work accidents or lifting or anything else, then I assert that the order is not supported by CSE.
Right. The JCC, though, did deny that there was a notice issue, right? On your claim about, or your defense about the notice, or it was untimely. If you run that time, 30 days, and if it's assumed that it was like May 22nd or a couple days after that,
Right.
Why weren't the WhatsApp, those notes or those communications enough to support his conclusion that that the notice that wasn't untimely because your client was on notice?
I find nothing in any of those communications that say anything about getting her to work. So it's not like if I just talk to my boss about the weather and they go, well, you talk to your boss about the weather. You got to talk to your boss about getting her to work. And there's nothing in any of those communications reporting a work accident. Look, I think that the central dispute is pretty simple on the cross appeal. If it's okay for the claimant to know he got hurt on the date of the accident, understand that, admit that he understood it, but he doesn't have to report it until a doctor says you have this diagnosis, then their point on the notice is well-founded. And if not, then...
Counselor, going back to the first issue, was the conflict in the opinions between the two IMEs, Drs. Smith and Freeman, broader than the question presented or issue presented to Dr. Scott, the EMA, to address?
No, the disagreements that were reflected in the two IMEs were exactly the issues that the judge asked Dr. Scott to address. There wasn't a did he hurt himself with a strain and did he hurt himself with a herniated disc. The question posed was, did he suffer a back injury or a neck injury on the date of accident? That's the question. It was a broad question. The doctors disagreed equally as broadly. And so I think the judge answered the precise question he was asked. It was based on the conflict that was existing in the medical records, and I think he did so appropriately. And I see that I am just about out of time. If you have no further questions.
One final question. Is EMA's opinion limited to the issue or question presented to the EMA by the JCC?
Well, the law is the EMA can address anything at all. The only question is whether the EMA gets a presumption of correctness. And the central question here is, did he suffer an injury to his neck or back while on the job on May the 22nd? And he evaluated, they say he did it just on his own experience. He spent 8 hours reviewing medical records and depositions. He did a physical exam. He reviewed diagnostic studies. And he said, I conclude there was no injury. That's it.
Thank you.
Thank you.
I know my time is limited, so I'll try to be brief. With regards to the cross appeal and the notice issue, notice has the 30 days, but there's exceptions to the rule, and the judge applied the exception properly. There's the reasonable person doctrine. The judge weighs whether the claimant was a reasonable person, whether that's applicable to the case, and it was, and that's the judge's determination. With regards to the...
Isn't that how is that not a question of law or something that we could re-review?
A reasonable person doctrine?
Yeah.
Well, the judge is the one that has the claimant in front of him. The judge is the one that's assessing the credibility of the claimant, determining whether, in fact, the claimant was a reasonable person.
Sure,
So
but is the credibility really even in contest? I mean, he said 3 times that, something happened in May, and he felt pain, and he traces it to that 4th time lifting the mattresses.
When the claimant was providing that testimony, that was after the fact he had already reported the accident. So it is a retroactive or application looking back. It is, right, hindsight's 20/20. Well, the claimant has been told that he has a cervical spine sprain strain. He's bringing a claim, which is the reason why he's being deposed. He has pain on that day, but he's being told at the emergency room, who's triaging him, who's working him up, making sure he's not dying, that it's possible heat exhaustion. So the judge made that determination. Notice was denied based on the employer carrier, and then we go forward to the EMA. The EMA is asked about the spinal condition. The EMA is the one, Dr. Scott is the one who specified that there is a difference between a muscular injury and a spinal injury. The EMA testified to that. The EMA even said that the claimant had a cervical spine sprain strain. He accepted the ER's diagnosis of a cervical sprain strain. So with that, he says, yes, the claimant had a cervical sprain strain, but I'm not relating it because there's no temporal relationship between May 22nd, 2019. So that opinion, the claimant argues, is speculative. And this court has already determined in the Oliveira case that speculation from an EMA is not to be afforded with that presumption of correction. In fact, that's not appropriate, and that clear and convincing evidence of an EMA providing that opinion based on speculation should be remanded back to the judge of compensation.
Why is that speculative when he says most of the sprains and strains resolve in 2 months? He didn't, unequivocally say never beyond 2 months. He just said most of them.
He didn't say all, that is correct, but he noted that in this case, he was looking back and saying, 2 months, that's too much for the claimant. So, I mean, that is speculation. That is an absolute response. That is not based on any other information other than he says most, if not all, or he says most, resolve within 2 months, or within a month, I think is what Dr. Scott testifies to. And that is a broad speculative opinion, not based on the facts of this case, and that's why it should not have been afforded with the presumption of correctness. That's why the speculative opinion was inappropriate to be rendered by the EMA, and that's why it needs to be remanded back to the judge of compensation claims to make more consistent findings based on the law that's supposed to be applied with regards to EMAs and with regards to the admissible evidence that the judge considered. So I respectfully request this court to remand the decision, and that's all I have.
Thank you.
Thank you, counsel. Thank you, counsels, for your respective oral arguments this afternoon. This concludes our oral arguments for this afternoon. We stand adjourned.